Hey there. Uh-oh. Okay. Hey there. This is Pam Perry, and I am. Oops. Say changes. We are here with our Speakers Magazine show. Was trying to go into LinkedIn, but they said I had to be approved for LinkedIn Live. Well, we're going to put it into LinkedIn after this, Darcell. So
Okay.
it's okay. It's good. It's good. So today we're going to be talking about, if you haven't guessed, godly ideas. And we're going to be talking about intellectual property. Hey, Sabrina Wood. Very good to see you. Very good to see you. So, one of the things we're going to talk about is intellectual property, trademarks, copyrights, all that stuff, right? Because we have ideas, but we don't want to get them stolen. So, let me give you a little bit of background about who is Darcell Walker and what he is going to be talking to us about today. He is, first of all, a speaker, and that's why it's called the Speakers Magazine show. He's a speaker, but he speaks, teaches, and preaches extensively on intellectual property. That was very interesting. So, like I said, he speaks, teaches, and preaches on intellectual property. And he's the author of a book called Godly Ideas: Developing and Protecting God-Given Ideas. And it's available on Amazon. He's an instructor at the University of Houston. So he's hailing from Houston, Texas, the Small Business Development Center for 10 years. And he also is an associate pastor for 9 years. And so one of the things that people always go up to Darcell and they always ask him, I have this idea God gave me. And he's always like, okay, let's figure this out. So kind of tell us from the very beginning, Darcell, when someone comes up to you and says, God gave me this idea, what are some of the first things that they have to look at? And what are some of the steps that they would have to do first, I guess you would say, in order to bring it to life?
Okay. When they first come to me, a lot of them they also tell me God gave me this idea years ago. So they've been sitting on it for a while. And really a lot of people, they sat on these ideas because they don't know what to do. So one of the things I tell them first is to sit down and write out what the idea is. Things like, what is its purpose? Why did you think of it? What is it designed to address? Is it designed to address some problem? What was your motivation for this idea? Because a lot of times ideas come out of necessity. So what is it that this idea is trying to address? And what you want them to do is you want them to sit down and actually write it out, because that becomes your first manifestation of it. See, a lot of people, they'll have an idea and they'll carry it around in their head and it's just there. But once you sit down and write it out, it becomes a manifestation. And it also helps you to think through the idea, because when it's in your head, it's just there. But once you have to think through it, and how does it work? What is it designed to do? These types of things, it helps you understand how much work you have to do to further develop the idea. So it's 5 steps in developing and commercializing an idea. The first step is called the perception. That's when the light comes on. That's when you now have it. That's the first thing that you do, and that's when you sit down and you think through it and you write it out, and helps you to understand what it is that you have.
The vision.
Yes,
Right,
because,
the vision.
Yes, because then you have to take that idea and turn it into a product, because for others to benefit from. So the second step is perfection. So now you have to take this idea and put it into a product form.
Okay.
Now,
is that like a prototype, or is that a...
If it's a mechanical device, it's a prototype. Say you're writing a book, which is an idea. So what you do in that step is you have to you create your outline, and now it's time for you to fill in what you're going to talk about. And so you're perfecting it. You're getting it to where it is a product. So that's the perfection step. And just like if you're designing some mechanical device and you have to go back and redo some things because they don't really work right, or if you're writing a book where you have to go back and rewrite some things, edit some things, when you write it out, it doesn't. No, it's not how I want to say it. But that's all done in this perfection step. You're perfecting it. You're getting it ready for its final form. And then the third step is the protection step. Now that's really what I help
That's
with.
the one. That's
Yeah,
the one where people,
yeah,
especially with songs,
yeah.
and where
With
people can
songs,
really get things stolen.
with all kind of literary works. But the protection step is where you protect it, and depending on the type of idea you have, dictates the type of protection that you have. So, so if you have some type of I just call it the artistic ideas. Those are the literary. Those are the books, the curriculums, the songs, the artwork, the paintings. All of that is what we call artistic. And
Artistic. Okay.
those are artistic ideas, literary, And so those types of ideas you protect with a copyright.
Okay. And the copyright goes through you gave me some websites and things like that, but should they do it themselves, or should they consult an attorney like you?
Well, I'll be honest with you. I'm not trying to promote what we do, but a copyright, you really can do that yourself. When we talk about it a little bit later, I can go into more details about what a copyright is. But back the artistic ideas, like the music, the songs, the stories, the books, all of that fits in what we call the artistic category, and that's protected with copyrights. And then you have the technical things. Those are the mechanical devices, the computers, the electronic things, the methods. All of that technical belongs in. It's covered by patents, by patents. Or in some cases by trade secrets, which is you're protected by keeping it a secret. But give
us the history of the difference between a trademark, a copyright, a patent, and trade secret.
Okay.
Without us feeling like we're going to law school, but like a basic.
A basic distinction. Let's start with trade secrets. Trade secrets. That's information that you protect by keeping it secret. An example is if you have a company client list that you may want to keep, that you may not want people to know about. You protect it with a trade secret, and that's in two forms. It's in form of legal agreements, like the non-disclosure agreements, the confidentiality agreements, and the other part of that is how your process that you go through to keep it a secret.
Okay.
A better example,
like your proprietary method.
Yeah, it's your information. It's proprietary. It's your information. A better example people may relate to are soft drink formulas. Soft drink formulas are protected with trade secrets. Coca-Cola, Pepsi, they all have these formulas, and they protect them with trade secrets. First of all, you can't disclose anything to anybody. And another part of the process is, say you have a process that has 5 steps. You may not have but 2 or 3 people in the entire company that knows all 5 steps. Everybody will know their particular step, but if you don't know the whole process, then the individual steps are meaningless. So trade secret, that's one form of protection, and that form of protection doesn't require any kind of formal registrations. It just requires legal agreements and what we call prudent business practices. So that's a trade secret, and some ideas, depending on what they are, like a soft drink formula, you may want to protect with the trade secret. Another example people might think about are recipes. If you don't want to put them in a book, if you want to just keep it as your own proprietary information, you would cover that with the trade secret, which means you'd have agreements and you'd have processes in place to keep this information confidential. So those are trade secrets. Now, the 3 that you register your idea with, the first one we're going to talk about is patents. Now, patents cover, like we said, mechanical devices, electrical devices, methods of doing business, processes, chemical compositions, all of the technical things, they belong under the patent group.
Patent, okay.
And then, as I said, the artistic
patents are hard to get, though. Do they take a while, or?
Well, the patenting process is the most complicated of the 4.
Okay.
It's also the most expensive of the 4 too. But to keep going, it also has the strongest protection of the 4. So, but they are harder to get. They do take more time, but it all evens out. It's worth what you have. If you have a patent for something, then you will really have something of value. You're trying to keep it. You try to keep control of it. Now, the 2 that pertain primarily to speakers would be copyrights and trademarks. And as I said, copyrights cover artistic ideas. Now, trademarks don't cover a particular type of idea. Trademarks cover what we call brands. Trademarks cover how you identify and distinguish your product from someone else's. So for trademarks, it's not an idea, but because trademarks include phrases and symbols and logos, those types of things can be artistic.
Okay. So Speakers Magazine would be...
Speakers Magazine is a publication which you would protect with a copyright.
A copyright.
Now, let me give you a little bit more information. This is the law school part here.
Okay.
Copyrights and trademarks have what we call common law protections.
Okay.
Which means you have certain protections in these works when you first create them. Like if you're writing a book, when you first go to your computer and write out your manuscript and complete it, that you at that point have a copyrighted work.
Okay.
The legal definition is a work that is affixed to a tangible medium, which means you can write it on paper, you can put it on a storage device. But at that point, you have a work that is copyrightable, and you have what are called common law copyrights. So
I heard this one thing, Darcell, where they call it a poor man's copyright, where you would take your manuscript and mail it to yourself and never open it, and then it was copyrighted. Is that a true thing, or is that
it's really not necessary. They also had it for patents too, but because you have common law copyright protection, you don't need to do that.
Okay.
That was normally done for you to identify when you first created it, but that's not necessary. So with a common law copyright, you have rights in that work, and you can at that point put your notice on there. Your Circle C, the name of the author, and the year the work was completed.
Okay.
You can put that on your copyright. If you're doing a drawing, whatever you're doing, if you're doing a drawing on a canvas and you complete it, you can go down to the bottom and put your name, Circle C, and the year for that, because that is at that point, because it's on a tangible medium, it's common law. Now you say, well, why would I go get a federal? Because the difference is the common law doesn't require any registrations. You don't have to pay anybody, but the rights that you have are limited.
Oh, it wouldn't stand up in court.
Well, with a common law copyright, you can go to court and you can get what are called equitable remedies, which means you can go to court and get an injunction to stop someone from copying your work.
Okay.
But you cannot get monetary damages with a common law copyright.
I get you. Yeah. All right. That's the thing. Yeah. So when someone like a screenplay, for example, someone writes a screenplay and they send it to a producer, and even though the producer takes your screenplay and makes it a movie, you didn't copyright it legally or through the court system or through the government, but you did common law. You could sue and they can stop it, but you couldn't get money.
Yeah. Now, here's the rest of why you want a federal copyright. Okay. That's one thing. You have you're limited monetary damages. With the federal copyright, the actual registration that you get is proof of ownership.
Okay.
See, with a common law copyright, you can go get an injunction, but you have to first prove that it's yours. You have to go back.
That means you're showing like a USB drive or...
you got to go through all kind of whatever evidence you have to prove that is your work. Okay. You have to do that with a common law. But with a federal, if you have your registration card, with a patent, copyright, and trademark, once you get it, you're going to get a certificate with a number on it. That's the registration, and that shows ownership. So with the copyright, the reason you want to get a federal copyright is, number one, is what we call constructive evidence of ownership. Number two, you can get monetary damages. Number three, the process is straightforward. You just answer 9 questions, fill out a form. And the fourth thing is the cost is inexpensive compared to a trademark or a patent. So with the copyright, that's why I would suggest people go and get your registration. It costs like $45 if you do it online, and that's if you make a mistake with the registration process for a copyright, you can start over.
Okay.
As opposed, if you try to do a patent by yourself, you make a mistake, you may not be able to start over. You may have lost your rights to it. So that's a copyright. Now, trademarks, along with copyrights, like you said, are for the artistic area. And with the trademark, you also have what I call common law trademark rights, which means once you have a product and you have your name for it or however you want to identify it, you can attach that brand to your product and use it in commerce, and you have what we call common law trademark rights.
Okay.
Now, there's another limitation with that. That's good because I can have rights without doing anything as far as having to go through some form of process. But with common law trademark rights, you are limited to the geographic area where you are selling your product.
Oh, I
So,
didn't realize that.
but that's the limitation. You can get those rights, but say I live in, and they're basically based on county. So I'm in Houston, Texas, Harris County. I can have a product here, and I can make it commercially available, but my common law trademark rights only extend to Harris County. If I wanted to move up to the kind of north of here, Montgomery County, I'd have to have somebody there selling it too. So somebody can't say, well, I sell nationwide, but I'm in one place. Well, your rights are only going to extend to where you are selling. Now,
Mhm.
the other part of that is say somebody decide they want to do uh, the same type of product that you have, and you have not registered your name, or yeah, you haven't registered your trademark name. So they go and they start after you, but they file a federal trademark for that name.
Mhm.
If they get that name, you can still practice where you were before they filed. But if you decide you expand, then you will be limited because they have rights.
Wow.
And the benefit of the trademark is it covers an entire United States and U.S. territory. So I may never come to Detroit or Michigan, but I can have a trademark in Houston, and if somebody is violating my trademark there, I can have recourse against them.
Well, how does that play? So say for instance, you were saying that trademark the name, but what if I have the domain name?
Okay.
URL.
Now the thing about domain names are they're not trademarks, but they have a similar function
Okay.
because domain names are designed to identify and distinguish you from someone else.
Right.
And you can trademark a domain name because
Oh,
because
okay.
a domain name is a phrase. It's
Okay.
words, phrases, acronyms, logos. All those things are how you identify and distinguish yourself, and all those you can get trademarks for.
Okay. So Sabrina asked, can you copyright a podcast?
Yes, because
Yes.
a podcast is a recording.
Mm-hmm.
And
Mm-hmm.
so it's a audio visual, it's a sound recording, and you can't copyright them. Now the thing about copyrighting a podcast is podcasts are series, and just like if you watch sports, if you ever watch a sporting event when they come back on, sometime during the event you will hear the phrase, "This is a copyrighted broadcast." And no reproduction or whatever is
Right.
permitted, that kind of thing. So a podcast is just like that. This show we're doing now is just like that. Those are artistic works that are sound recordings that are copyrightable, just like if you released a song.
Or what about a lot of churches aren't meeting because of COVID-19, so they aren't meeting in the building. They are meeting online. So
Mhm.
talk about how pastors that are streaming live, how is that copyrighted? Is it just
Those again, those are broadcast.
okay?
And so they still fall under that category of artistic works that are sound recordings.
Okay.
and
Okay.
and and so yeah, I have a whole I have a whole product that talks about churches in particular, because there's some things you have to be careful about when you do broadcast. Because for example, I have images of my books behind me, but sometimes you can do a broadcast and you can put somebody's artwork behind you, and sometimes depending on what it is, you may be violating their copyright, because a copyright gives you the right to reproduce, to distribute, to display, and they will say, well, you're
Oh,
displaying my artwork without my consent. So
yeah. Oh
now
my goodness.
that generally doesn't happen, but it can.
Right. Right. Then there is this thing on Facebook and also I guess all of them, YouTube or whatever, where we talk about you said, do I separately copyright each podcast episode? Um, Well, I'll have you answer that, Darcell, but I'm thinking not.
Now, but when you have a series, you don't necessarily have to go and get a copyright for each broadcast. That's the benefit of the common law copyright. That's a benefit. You don't have to go and copyright each one. A better example, not a better, another example is if you have a CD with 8 songs on it. Okay, each song itself is an individual copyrightable work.
I can see that.
But and then the 8 together of what they call a collective work. So you can copyright the 8 songs as a collective work, and then you can go back in, and the ones you think may be more successful, you may go back and copyright some individual ones.
Okay.
So when you have a series, we have a periodical. Generally, you may copyright an article, one edition here or there, but generally you would not need to, because they happen every week or every periodically. So you don't necessarily need to go and copyright the magazine or the periodical. Now, within a periodical, you can have copyrighted works in your magazine. Say somebody puts a story in your magazine, and that story is a separate work, or somebody may have some type of artwork that they put in your magazine, and those might be copyrightable itself. Now, generally,
so this would be copyrighted, the artwork itself.
Well, that photo, they could claim, that photo. Now, generally with magazines, and you probably do this too, in order to put the work in your magazine for that particular situation, the author will release rights to you.
Exactly.
For, to use for that purpose. And you can't go and put it. You can't put it in everything else. You can only use that work for that particular magazine.
Exactly. Yeah, I just can't go to Google and just pull down a picture.
No, you can't go down and put on a picture, and you can't use that artwork for your magazine and then do something else with it.
Okay.
It's only it's for this particular purpose.
Wow. Okay, I got it. So what about music that people use on Facebook and they type this little thing, "I do not own the rights to this music"? What is that all about?
That's a disclaimer. They're telling you, this is on here. I'm putting it on here, and the thing about how you enforce intellectual property, a lot of times people are using unauthorized works, but the owner, do you really want to enforce it? Because in honesty, people putting your music on Facebook is really publicizing for you. They're really doing you're gaining something from it. So, and a lot of times, people that put it on these other mediums, they're just broadcasting it. They're not misusing it, So the owner doesn't have a problem. Now, if someone is misusing it, and the people who have the rights to it find out, then they may come in and approach that person, about it. But it's just a disclaimer that says this is not my work. So if you take this and you do something with it, I have nothing to do with that. I don't care if you did get it off of my site. I told you that I don't own this. So if you decide you want to use it for something, then it's between you and the owner. You can't come back and say, well, I got this from Pam Perry's website. Well, Pam Perry didn't own it, and she told you she didn't own it. So, if you're using it, then that's your decision.
We're talking with Darcell Walker, who wrote the book Godly Ideas, and the book is available on Amazon. It talks about really protecting your godly ideas and really how to bring ideas to market so that they can come to the marketplace. Darcellwalker.com. The thing that is interesting to me is the music. This is the thing. So Facebook and YouTube will put you in jail, Facebook jail or YouTube jail, or you'll go back to YouTube school because you use someone else's music under your slideshow, whatever. And a lot of times people will say, well, I got the rights to it, or I said I didn't have the rights. The whole thing just really confuses me. And so when I see something like TikTok that definitely uses other people's music, I can put that on Facebook and it's okay. Does TikTok have a different arrangement with the artist, or I don't understand?
It'll be hard to know and to know. Facebook and TikTok may have some kind of arrangement, but what happens is this. See, like I said, you have the owner of the work has the right to display the work. So if Facebook allows it to be displayed on their platform, and they don't, they don't ensure that the person displaying it has the right to use it, another legal term, they could be viewed as a what's called a contributory infringer, in that you are Facebook is enabling an authorized a person who's not authorized to use this work to use this work. Now, like I said, these cases don't come up. If you see a case like this when somebody's getting sued, there's probably some record company, that kind of thing. It's not individuals. Right. And as far as Facebook and TikTok, they may have some kind of arrangement, because that concept applies whether it's regardless of the platform.
Okay. Yeah. Because it must be, because you're actually using the music. I mean, it was like the Beyonce Savage Challenge, and it was Megan Stallion and Beyonce, and it was definitely their music, but people were using it. So it's just confusing for people, I think, that try to figure out how and when they can use the music, and especially a lot of dance classes, they use music and they're streaming, and they may stream online, and it's like, are they going to get in trouble? Or when someone is if they don't own the music and they're doing a battle of the bands, so to speak, and they're just playing music of the artist and they're doing a battle, but they're like two DJs doing a battle, then is that okay? It's just a real murky new area.
Let me complicate matters a little bit more. Sometimes with Facebook and TikTok, Facebook may be using TikTok as like kind of a screener, so it's like if you let it through TikTok, I'll let you use it. Other times, some people have a license to use music. You can go, I don't have the name on top of my head because I don't do it as much, but like churches, a church plays a lot of music that they hear on the radio, and those kind of things. And see, that's a performance, which is also a right that the owner has. But you can go, if you're a church, you can buy a license from I think it's the Copyright Licensing Company, CCLI, whatever. But you can buy a license that'll give you the right to play this music in your services. And maybe there are other people that they will have like a master license where they can use certain musics.
Yeah.
It's kind of like you see it with photos too.
iStock or whatever, where you can license and use it. Yeah, you
can buy a license from them, and you can use like all their photos, something like that. So some of that may be going on why some people are not being approached, because they've gone out and paid the money to buy a general license that covers all of these different categories.
And that's what I'm thinking they probably did do. That's
probably now what they will do. They will tell you, I have a license to use this music for my platform. But you don't have that license. I do. So if you use this music, if you take it from mine and use it, then you can still be liable.
Okay. So then that whole music piece, and then the other piece is pictures, because people think like, well, I can use this picture on this flyer. I Google it and whatever, or I'm the cover of my magazine. I'm gonna use this picture, or the cover of my book. I'm gonna use this picture. I found it on Google. The whole point of it at the bottom of those pictures says this picture may be copyrighted to such and such. And like you said, are people enforcing things more because of social media? That's the main thing. Are people enforcing things more? Is this really, how long does something, like if I sue somebody, how long is that going to take? Is it like months or years? And people just say, forget it.
Well, one thing people, they put those notices on there so they won't be liable. It's like, okay, I put this on here. I told people this is not mine. It may be subject to copyright. So I've done my part. I'm not contributing to your to what you're doing. And so that's one of the reasons why you see that on there. You were going to say something else, and I forgot what you were going to say.
Right. No. Because people will then, how long does this, if someone says, well, I'm going to sue because they did use the flyer. On their flyer, they used my picture, and I didn't authorize that. So how long would a lawsuit from beginning to end take? And then people just get tired and say, forget it.
Well, in my experience, people really don't sue you unless you're making money. Okay.
Okay.
All right. So you can sue me for using your picture, but it's going to cost you more to sue me than you'd have gotten if I had paid you to use it. So it's really not worth your while. And so a lot of people, they won't, it's not worth it if you're not making money. If you're making money off of it, then that changes the dynamics. Plus, let me complicate your life a little bit more. In copyright law, there is a set of exceptions where you can use a work without the owner's permission and not be liable. They're called the main one is called the fair use doctrine, where that for certain activities you can use a work that's copyrighted but not have the owner's permission to use it, and those are called the copyright exceptions. So
Is
and
that
one
like common use or not common use, but common license? I think I see that on Flickr sometime where there's three different types of pictures that you could you can make your picture common use or common. I can't think of the name, Darcell, but
well,
it's
I don't know, that may be, but for example, if I want to use a picture when I'm teaching my class, because educational use is an exception.
okay.
where,
Okay.
where, where you can use an image, or you can use somebody's material for if you're teaching a class.
A
And
PowerPoint.
so yeah,
Hmm.
so that is an exception.
Okay.
News reporting and journalism is an exception. So I can use it. I'm doing a story for news or for a paper or whatever it is. But so there are some copyright exceptions
Okay.
where you can use a work without their permission and not be liable. Well, I always tell people, try to get it if you can anyway.
Hmm.
But there are some cases where you can use it, and you if they had an issue with it, you say, well, this is a fair use. I mean, this is a copyright exception. It's under the fair use doctrine, and the fair use doctrine lists these different situations where we can use a work that's copyrighted without consent. Let me say this real quick. This is another thing about copyrights, and I don't know how many people actually design their own websites, but that's another area where if you do, you have to be careful about putting things on your website that are not yours. You know,
Ooh,
you
a
know,
lot of people do. They'll just grab it and just do
when
it
you go, yeah,
yourself, and
yeah,
they
yeah,
don't know. And it's like, I'm just putting it on there.
yeah.
I found it on Google.
That's the point. You find it on Google and then you put it on your website. So now you are really violating the copyright. That's if you do your own. Now, if you have a webmaster, somebody, they already know not to put anything on your site that they don't have permission to put there. And
Hmm.
if that happens,
You're talking about like artwork and things like that.
yes. Mhm. But,
Hmm.
but but that can happen, and you have to be aware of it, because a lot of times the response is, well, I didn't know.
That is it. Now, I hear you said a lot of times people will take people to court if they're making money. So, say for instance, I use, and I hear this all the time. Les Brown has a famous speech. You got to be hungry, right? You got to be
Mhm.
hungry. It's Les Brown. It's his voice, and it's his voice in this whole video. But it's not him. It is pictures. It's like a slideshow, and it is Les's voice. And so the person goes on and they get, I don't know, 100,000 views because they love. You got to be hungry, that
Mhm.
whole speech by Les, but it's not on. Les is not getting any money. The person who put the YouTube up has monetized their YouTube channel. Now
Mhm.
that is something that he can go after them for, correct?
He can call them unless they've got an agreement already.
Right, right.
So it's I don't know, but I would not believe somebody would have a person well known as Les Brown using his work and have that much popularity, and there have not been some arrangement that's been worked out. Like, again, the person using Les Brown is promoting Les Brown too.
Right, right.
Even though this is a
A
older,
monetized channel.
well, and this is an older speech. It's not a new speech. So
Right.
there's things that are in place. Probably, I'm saying probably, but when you look at it on the surface, it looks like, well, they're using Les Brown stuff, and Les Brown's not saying anything. Well, he may have already licensed right to use. Said they come to Les Brown and say, I'm gonna license, and he'll license that speech to use on his YouTube channel or something
Hmm.
like that. So now, if that person decides to use it somewhere else, then he may be violating his license agreement with Les Brown. But that's a situation that may be what's going on.
But then, yeah, and that's why it's important for speakers to especially copyright their speeches, or to
Mhm.
make sure that people aren't taking their speeches. If they record someone, say, I go somewhere and I hear a speaker is,
Mhm.
and I record them with my phone, and
Mhm.
then I put it up on YouTube. Am I violating that speaker's copyright?
Yes.
Ooh.
That's why.
That happens all the time, right?
But you
People are
know
like,
that a lot of times when you go in places they say no recording. Like you just said when you go to the movie theater, you can't be recording this. You can't. We want all these. Some places they make you give up your device before you come in. But yes, that is an unauthorized recording of a work. Now, like again, it matters. Is it worth your trouble to go in after this person? Now, if they're doing like if this person is using Les Brown's material and he's using it in a way that's damaging to Les Brown, then that's that's not really helping Les Brown. So you can come in and do something because that's hurting you,
right.
and whatever. So yes, but when you do that, those are unauthorized actions. Like I said, now most a lot of people they used to have all the bootleg movies and stuff. It's you're not losing. It's not worth it for you to go and try to stop them because it will cost you more to enforce it than it would be to the little money. As I think you said one time, the people who buy the bootleg copies not going to come to see your movie anyway.
No.
So you're not really losing anything because they weren't going to buy it from you in the first place.
So then the important thing to do is when you're copywriting books, speeches, workbooks, paintings, videos, core curriculums, is to protect you, to make sure, give you a good example, to make sure no one steals it, for one, and says it's theirs. But if someone does try to use any parts of it and they're making money from it, that's when you should probably go to court.
Yeah, that's when if you want to do it, yeah, you have a right, that's your right of recourse to stop them is to go to court, and depending on whether you have a common law copyright or a registered copyright, that's going to dictate what you can ask the court to do.
Ooh, okay. And depending on what type of copyright you have, whether they have a common law or whether they have the federal one.
Yeah, because you can't get in monetary damages with the common law copyright. You're going to have the court to make them stop.
Okay, so that right there is like the main thing. That is the thing. Patents are. There's a lady from Detroit. Her name is Gwen Jameer. She has a hair care product called Naturalicious, and she is the first Black woman to actually have a patent for a Black hair care product. You believe that? I mean, this just happened like a couple of years ago, and I'm thinking, like, out of all the things that we Black people have been having black hair our whole life, right? And this is the first time that we have patented our own hair care product. It's for natural hair. That is pretty amazing to me, and that has been a shift. It made a shift in her business in terms of marketing and branding. I don't know if someone. It's like the patent you were saying. Is that like a trade secret patent? Is that
the when he talks about patents, she has some kind of hair care product. Okay, there's a question. Anytime you get a federal registration, whether it's a copyright, a trademark, or a patent, it's going to become public. They're going to publicize it. It's going to become public. And the question you have to answer is, I don't know what's in our patent, but sometimes, be like the Coca-Cola formulas, if it gets publicized, people could copy you, but you not necessarily know that they're copying you. See, like I said, with soft drink, there are, I think, more than 20 different cola formulas for that flavor, for the cola flavor. There are like 20 different formulas. And so if Coca-Cola's formula became public and somebody came up with another drink, Coke doesn't know if they are copying them or if they have their own. And in that case, the only way you can find out is through a lawsuit. Then your trade secret will get destroyed because it have to be disclosed.
Wow.
But with the hair care products, it's similar to that. Like I said, I don't know what it is. Sometimes it's in the actual the actual components, the actual product that you put in your hair. I know lady one time she had a patent for how you can hold your hair up. It's different device that you put in your, I'm not a woman, but you put in your hair to hold it up. And it depends on what it is. Sometimes it is a method. Here's a product, but you have to apply it a certain way for it to do what you want it to do. And the patent could be in that process. But in that case, the value there is in the product and in the brand name of the trademark.
Right. And really, when she did get the patent, it made her brand stock go up
Yeah.
because people just felt like, wow, you're the first one to do that. So anyone after her was like, well, but Gwen Jameer already had a patent, so it's a different patent, but it's over a black hair care product. So she's in a lot of stores and Target and that sort of thing. But she started at her kitchen table
Yeah.
with a bad idea.
One of the reasons why you protect your ideas, is it adds value to the product. So
Mhm.
when you see a lot of products, even before the patent comes out, they will put on their product patent pending, or they'll put on their product patented product. So it lets people know, first of all, this is something that's original. Nobody else has done this beside you. So and that's something that you can use to advertise it. You see it with trademarks too. This is a trademark. This is a registered trademark of so and so. This is a copyrighted broadcast. That's in part to ward people off from trying to copy you, but it's also a part of letting people know this has a value.
That's
And,
true.
and,
It
and
does.
so you see it in marketing. That you really see it in patent, with patented products, because that's one thing they try to sell, is that this is patented. So you can't go out and try to find it somewhere else. You can find another product under a different trademark name that may do the same thing as two products that do the same thing under different trademark names. But for patent, if you want this particular product, this is the only place you can get it. So yes,
Mm.
it does. It has a lot of purposes. I.
Positioning. Yeah, it does. It has like a positioning, because I buy a particular makeup wipe and it says
Mm,
patent pending. And I've
mm,
probably been buying this makeup wipe for about 5 years at least probably longer than that. And it's patent been pending for about at least 5 years. But I buy it because it says patent pending. It does make a difference. In my mind, it's like, oh well, this is not just a little makeup wipe, but it's a patent pending makeup
yeah,
wipe. So
yeah.
in your
So
mind, it thinks it
and that goes back to, like we talked last week, about the importance of what we call labeling. That's why you put your notice on your work, whether it's a
Mhm,
copyrighted work, whether it's some kind
mhm.
of brand, whether it's a patent. You want people to know this is owned by so and so, or this
Yeah.
is protected. So and so that's the importance of it. And when people see that, they're less likely to try to copy it. They will be more likely, if they like it that much, to approach you and try to work out some type of uh,
Collaboration or
yeah,
enumeration.
some type of partnership, and
Mhm.
in a lot of cases, people are welcome to that, because that can help them further get the product out.
Right, right. Ooh, it is a lot, Darcell. It is a lot. So, Darcell Walker, tell people how they can get in touch with you, because there's a lot of information. I mean, it just the more I talk with you, the more questions I have, and
Mm.
it is. I know you can't cover all 29 years of doing IP in this
Well,
broadcast, but you do have a couple of books. So, tell the people where they can get your books: God's Property, and then Godly Ideas.
what Godly Ideas is, it's not as it's more like a manual that
Okay.
helps with churches and other organizations. Actually, if they go to my website, darcellwalker.com, there's a products page with different products
Oh, okay.
on there, and I learned. Maybe I learned this from you. You try to have something for everybody. So there are a lot of different ones, like my book, and then I have some workbooks, and I have some more audio visual type products. But I do know
And they're
this.
copyrighted, of course.
Matter of fact, let me say this real quick. You did put the notice on your work. I saw it.
Mhm, mhm.
And when people, if they want to know the copyright notice, this is for the authors and people that create information materials. The copyright notice is the Circle C, the name of the author, and the year it was created. Now, those are the basic elements. Now, you can have other phrases like all rights reserved and no reproduction without
Yeah.
consent. Now you can find that language. If you go to most books or magazines, you may be able to see that those expanded notices. But you need to have something on there, because if people just see it with nothing on there, it's like, oh man, this is, it's almost like finding something, finding money. Well, nobody's name's on it, so it's mine. Uh,
Right.
but that's a small thing to do, and people may not realize it, but it can be very important.
Mhm. I remember years ago when Kinko's was around, and you would give Kinko's a copy to make a copy of. And they said, we can't copy this because it's copyrighted. It had a small C at the bottom. And it was
Mhm.
like, what? I said, but this is for such and such. They didn't care. But so I can see what you're saying, that we need to have that on all our materials. And podcasts are really booming. So people need to have it on their podcasts as well. And always a circle C at the bottom. So it's
Mhm.
the circle C, the name, and then the year, or is it the name, the circle, the circle?
Well, the order is not important.
The order's not important. Okay. All
As
right.
long as you have all three elements, it's the circle
Okay.
C, the name of the author or whoever owns a copyright. Because sometimes, if we did we could do a whole segment on copyrights. Because what happens sometimes, somebody will hire you to create something for them, and it will become the work of the one who hired you.
Ooh.
Even
Okay.
though you actually created it, you created it for, it's called a work made for hire,
Mhm.
and something that this is for the authors in particular and people in general. Because I had a lady happen to, if you have someone, you have an editor or you have a ghostwriter, you have anybody helping you with, you need to have an agreement in place with them as to what they own and what you own,
Wow.
because sometimes they will try to claim part ownership, and the way intellectual property laws work, the person who actually creates the work is presumed to be the author or the inventor of the work.
Wow.
And
Now
now
that's
yeah,
deep, because a lot of people use ghostwriters for blog posts and things like that.
mhm. Now the thing about it is, you can have a website that they'll tell you, if you submit something to this website, then we have the rights to use on this website. That's why it's good to read that. Most websites have, do you agree with the
Private.
term? Yeah, do you
Yeah.
agree with the terms and conditions? And one of them is, if you submit something to our website, we have the right to use it. Or if you submit something to our website, you are saying you have the right to do this. You can't take
Mhm.
somebody else's, because what happens is, if they get sued, they're going to come back and sue you under breach of contract, because when you click I agree, that's like signing a contract with them. But
Wow.
that's
Yeah. Every
that's
website should have that, and I have a privacy tab and terms of agreement tab, and that's really really important.
but
But
but but
This is
I would say, not to scare anybody, but I had a client like that. They had a ghostwriter and they wound up suing the ghostwriter. you know,
because the
the,
ghostwriter was like, I'm the person that
the
wrote.
ghostwriter was claiming that they own the work. They helped them write it, but they claim like they own the work. So that's something with authors that can kind of get you, because you're gonna have somebody that's gonna edit what you put what you write.
Mhm.
And the thing is, you need to have an agreement in place where you compensate them for what they're doing for you, but they don't have any rights in what they're
Right.
producing.
That you have to make that clear. That
Mhm.
is so good. That is so good. And music the same way. I
Yes.
can see where a musician will say, "Well, I wrote it," and then the writer said, "I wrote it," and then together, well, who owns it? I mean, yeah. So it can get murky. So that's why it's really good to have an attorney that knows IP, intellectual property, especially
Mhm.
under this artistic
Mhm.
manner, and pastors too as well. So that's it. All righty. Well,
Yeah.
thank you. So someone said, "Good point, good point."
Mhm.
So what Darcell, I want people to go to darcellwalker.com, hit your products page. He's got a lot of workbooks and things there, and I'm telling you,
But
you
and
can't, you can't use
if
the excuse that you don't know, because you.
and because they're listening to your show, if you have any questions, you could email me. It's dw@darcellwalker.com, and I'll try to answer your questions for you.
Cool, cool. All right. Did you get that? It's dw@darcellwalker.com. Cool. All righty. Well, thank you, Darcell. Thanks for being on the Speakers Magazine show. And we will be
Mhm.
seeing you in the mag soon.
All right, thank
All
you.
righty. Bye bye.